we ought to be focused on achieving bias-free workplaces. We ought to be aspiring to achieving a way in which everyone, men, women, people of color, people of different sexual orientations, have an equal shot to get to the top.
And so the mission statement is just a start. The ABA then came out with Model Rule 8.4G. And it's broader than just gender bias, but obviously today that's our topic, so we're going to focus on that. And lots of conversations and issues concerning Rule 8.4G. We'll spend a few minutes talking about it now. So it's professional misconduct or unethical to engage in conduct that the lawyer knows or reasonably should know is discrimination on the basis of various things, sex being one of them, in conduct related to the practice of law. So let's unpack that for a minute.
The first thing to recognize about 8.4G is that it is a model rule. The ABA has no jurisdictional authority with respect to people practicing law. It's simply an association of lawyers. But what this rule is a recommendation to the state licensing and disciplinary authorities that they ought to have a similar rule, that they ought to make this kind of rule part of their rules of professional responsibility, which means that if a lawyer, if a law firm, if a legal organization discriminates, if they do something that is biased in a way that injures the career opportunities of a protected group, they are guilty of a violation of the rules of professional responsibility and are subject to discipline. Now that's pretty serious stuff. We're not aware of any case in which that's happened yet, but we do know that many states have adopted rules identical to or similar to 8.4G, and that many more are considering it. So our profession has an aspiration towards gender-free workplaces, and it has been recommended that our state disciplinary authorities make certain that those that don't adhere to that aspiration are subject to discipline.